record on this computer. Alrighty. Are you guys getting the recording button on your screen? Yes, you are. Good. Okay, so welcome to the first of our presentations. This is week 8 and the presenters are going to present to us their proposed fair dealing guidelines for a media franchise. And the franchise that they've chosen is obviously, as you can see on the screen, the Pokemon franchise. And the whole issue of fan fiction and what you can and can't do in terms of copyright infringement is a fairly prickly issue, and it's only gotten more prickly with the Productivity Commission's recommendations just recently. So I'll be very interested to hear what our lovely presenters have in store for us. This week we have presenting Lily Williams, Patrick Fitzgerald, Angie Conn and Caitlin Peterson. So without further ado, I hand it over to you guys and I look forward to your presentation. Thanks.
Good evening, everyone. So as AJ just introduced us, we are the Week 8 group looking at fair use dealing, specifically looking in particular at fan art and fiction. As she said, yes, we are doing the Pokemon Company, which is in fact a daughter company of the Niantic group. So without further ado, sit back, relax, and enjoy the presentation.
Nice. I love it.
So we will have 5 seconds to this evening's discussion, and I'll be beginning with treating your audience as king. So what does that mean? So when drafting any form of guide, the intended audience must be considered, as it will impact on the language used within the guide, the presentation form of the document, as well as the provisions themselves. So who is your audience? In the case of our portfolio, Pokemon has a large and varied audience, so the large demographic of young people should be especially considered. This is particularly important when you consider the ability of individuals to be able to understand and agree to terms and conditions. Furthermore, due to this demographic, the way the public interacts with the Pokemon franchise will also vary. Special consideration must also therefore be made on how individuals can access the Fair Use Guide. The title of the guide should be clear and to the point as to be easily identifiable. Accompanying words may be necessary to describe the purpose of the provisions, however. To lay persons, fair use may not be something to be understood or deemed important. The guide should also be easily accessed from every aspect of the website, web applications, print media and texts, and upon opening any Pokemon-related applications. Links to the guide should be in either the header and footer of such applications, and additionally, when first signing up to the website, accessing the game, or utilising a mobile application, individuals must acknowledge they've read and understood the fair and agreed to the Fair Use Guide's provisions. Our Fair Use Guide stipulates that when you access any of Pokemon's websites, web applications, games, mobile applications, or print media, you agree to comply with the following conditions in relation to our intellectual property, and this applies to all content branded and controlled by Pokemon. As previously stated, the target demographics must be considered, and whilst a degree of complexity is needed to convey key legal principles, the guide should remain simple in form and language to convey meaning. Often, key terms glossaries may be helpful. There are a number of examples within our guide that show careful consideration of the key, making sure that key terms are explained correctly. It may also be relevant to have an accompanying "what does this mean" section to explain even simpler terms what the rules and responsibilities described under the guide pertain to, particularly when dealing with an audience containing such a large youth demographic. Indeed, a user's guide was added to the end of our Fair Use Guide in order for the public to better understand their rights under Pokemon's terms of fair use. Here we have an example of the text from the Fair Use Guide versus the user's guide to show how we've been able to adapt it to make it more simplistic for viewers to understand. Now I'll pass on to Angie to begin our discussion on overcoming ambiguities.
Hi guys. Okay, so can everyone hear me okay? Okay, So before examining how ambiguities may be overcome and how risks can be managed, we first need to clarify the underlying statutory framework. Australia's fair use equivalent is fair dealing. These exceptions to infringement in the provisions of the Copyright Act are very specific and limited. Copyright material used without permission for the following purposes may be considered a fair dealing in an Australian jurisdiction, and they are therefore permissible. So the current framework that underpins the guide is found in sections 40 to 42 of the Copyright Act. So you can see them up on the screen there, and I'll just go through them for you now. So the first one, the use of copyright materials may be considered a fair dealing if it is for the purpose of research or study. So this may be copying 10% of the number of pages of words of a text or notated music. Given that Pokemon's IP is primarily characters and animations, it would be actually considered on a case-by-case basis if a court is that the use of copyright materials may be fair dealing for the purpose of parody or satire. So parody will involve imitation for the purpose of making some comment on the work or the author. Satire, may involve some form of imitation. It may be ironic, may be sarcastic, it may ridicule. This already narrow exception, though, actually insists on some form of commentary. So it's not sufficient to merely be humorous or mockery. The fourth exception, as you can see on the screen there, the use of copyright materials may be fair dealing for the purpose of reporting the news. And of course, the author and title must be acknowledged. So I think a really important thing to clarify is that the fair dealing provisions that underpin this guide do not reconcile with fan fiction. Fan fiction is fundamentally for the purpose of entertainment, and this is just simply not one of the fair dealing exceptions. So we had a look at comparative jurisdictions. Unlike the Australian model, the United States have a general fair use exception. And as you've probably noticed, the whole thing is a fair dealing, fair use exception, and it's more what we commonly think of it as. So perhaps because US culture is somewhat ingrained in our subconscious because of the mass media, what we're really seeing with the phenomenon of fan fiction is a blurring of the lines in our community standards that reflects the laws of the US more so than Australian laws. Without a general fair use exception, fan fiction is currently outside the scope of Australian law and actually in a very grey area of legality. So while the doctrine of fair use is not binding law here in Australia, there are actually two reasons why it may still be influential in an Australian court in defending fan fiction. The first is that to fill the gaps in our own laws, the court may look to an overseas jurisdiction for guidance. And when we run through the factors a US court would consider under the doctrine of fair use, which Lily will talk about shortly, it actually becomes apparent that an otherwise infringing fan fiction piece may actually be acceptable. And I found it not surprising that our laws reflect the narrow copyright exceptions of the UK. So the fair dealing provisions under UK copyright law vary only slightly to Australian fair dealing provisions. So of course, any influence coming from a UK jurisdiction will only further compound the illegality of fan fiction. So it's also the current law reform agenda in Australia that may see fair use as being more influential than just something that the US does. The most recent Australian Government Productivity Commission inquiry report last year recommended implementing a broader fair use law here, as in the US. And this has been recommended before. So the doctrine of fair use may have some influence in an Australian court as extrinsic materials if, when trying to fill the gaps in our laws, the court looks to propose law reform for some level of guidance. Despite all this, though, it was critical to remember when we were drafting the guide that to be enforceable, the guide must stay within the existing framework of the existing laws. This is not so much an issue for the media franchise, as copyright laws are strong for owners. It could be difficult, though, for a potential copyright infringer to demonstrate that a fan fiction piece is within the current statutory exceptions and therefore permissible. A fan's Pokemon art, for example, is unlikely to be successfully proved for the purpose of research or study, criticism or review, parody or satire, or reporting of the news. Maybe some pieces could be argued to fit the parody or satire exception. However, this provision is actually more narrow than it sounds, as we've said, given the requirement of commentary in the potentially infringing piece. So commentary may be, but it certainly isn't always an element of a fan fiction piece. Users, I think it's probably important to note that users are unlikely aware that the permissibility of fan fiction in Australia is ultimately discretionary. It is just not a given legal right that we have here. Despite this, media franchise, though, has a valuable relationship to preserve with their fans. And Patrick will talk more about this in ensuring commercial success later in the presentation. The reality is that the media franchise is likely picking their battles in the interest of not alienating their fan base. They are essentially allowing fan fiction, which without a general fair use exception, it's really outside the current exceptions and it is not within the letter of the law within Australia. So there's unlikely to be an attempt to enforce action to stop any fan fiction work unless it starts to cross the line from entertainment to generating commercial gain. And this is not uncommon. Unauthorised fan art may be sold. Fan fiction works may generate profits for third-party platforms, such as YouTube, for example. And this is an important factor that would trigger a franchise seeking to enforce their rights against a fan fiction author. So authors of the guide have the opportunity to take a practical stance in that terms may reflect how IP is really used by fans. Law reform proposing a general fair use exception is really arguably an instance of the law catching up to how fans have already used IP for some time. As the current narrow exceptions discussed demonstrate, there is no general fair use exception in Australia, in Australian law at this time. So to account for this, we have put two terms into our guide. And so these are that we may choose to permit the reproduction or publication of content by users where we feel that this does not harm the integrity of the Pokemon brand. The permissibility of such use is our decision, and our decision on this will be final in any such matter. And the second term that kind of deals with this illegality aspect of fan fiction is that if we choose to permit the reproduction or publication of content by users, but later decide that such use does harm the integrity of the Pokemon brand, or for any other reason, we retain the right to take action against such use at any time, as per these terms and the laws of the Commonwealth of Australia. So I'll hand over to Lily now to talk some more about fair use.
Alrighty, hey guys. Alrighty, so I'm going to be talking about the degree and purpose of a recreation. So in drafting our intellectual property provisions relating to fan fiction, the degree in purpose is particularly relevant. Purely in entertainment purposes for an individual is going to be acceptable, whereas fan fiction for the purpose of making a profit will be clearly unacceptable. When we talk about degree in this context, it refers to the extent that Pokemon is present and recognisable in the recreated work. If you've created a short movie influenced by Pokemon, the courts will look to what you have borrowed from the original work, and infringement will depend upon whether the amount is a substantial part. A substantial part doesn't simply refer to the quantity, but to the work as a whole. So it's likely to apply to the central concepts. So the characters, using Pikachu as a character, or the plot, or the setting, such as using the Pokemon world in a short movie that you recreate. The substantial part may also apply to minor concepts though. So if they're borrowed and expanded on in a new work, that will also have liability. So when we refer to purpose in this context, it strongly relates to the author's intentions from recreating. So in other words, what function does the new work serve? So after discussing those two elements on purpose and degree, there are 4 other fairness factors, which have been recommended by the Australian Law Reform Commission only recently, as Angie has just explained, but they should be considered here. So they're common to both the US fair use provision as well as the existing Australian provisions for fair dealing, but only under the purpose for research and study at this point. So it's important to remember that these fairness factors are not within the existing Australian jurisdiction. However, they have influential value as extrinsic provisions in determining the law. So I'll discuss each of them now. So the first fairness factor is the purpose and character of the use. 2 issues are to be considered under this factor, whether it is transformative use and whether the character of the use could be classified as commercial. When we refer to transformative, we understand it by looking to see whether the use has taken on a new purpose, so it's distinctive from the original. A commercial character will be evident if the new work is to generate any gain, particularly profit. The second fairness factor is the nature of the copyrighted work. The US court gives weight to 3 different elements in considering this factor: whether the work is published, whether it is in print, and most prevalent is whether the content is factual or for entertainment. This being because if it is of a factual nature, it will often be excluded from copyright. So the third fairness factor is the amount and substantiality of the part borrowed. The central focus of this factor is whether a substantial part of the original work has been borrowed. In US courts, it's as well as Australian courts, an emphasis has been placed upon not only the amount of the borrowed work, but the amount in relation to the whole work or adaptation. So the borrowed part itself may be small, but the influence overall may be large. So the courts will look for that. So the fourth fairness factor to be considered is the effect the use has upon the potential market. This factor particularly concerns the effect that the new material will have upon the copyright owner's rights and their dealings with their own work. Specifically examined in case law is if any effect to the author's earning capacity is potential. If development of the new material would have an ability to replace a sale of the original work, then fair use will not apply. This factor isn't particularly concerned with fan fiction. However, it does arise every so often. This was evident in the Harry Potter encyclopedia case. I'm not sure if any of you remember reading about that one. It involved the fan-made lexicon, which was an encyclopedia to the world of Harry Potter. The case was Warner Brothers and RDR Books. So RDR seek to publish the fan-made lexicon, but were stopped because J.K. Rowling herself was in the process of publishing her own encyclopedia. So if Lexicon were to have been allowed to distribute their own encyclopedia, then the potential of J.K. Rowling's profitable